Thank you for tuning in to Brock Eichler Talks, where we explore and discuss today's trending legal topics. Today I'm here with Brock Eichler member Jay Sabin. Jay is a seasoned labor and employment and transportation attorney with extensive corporate experience as in-house counsel to a regional third-party logistics provider and the New York Times. How are you doing, Jay?
I'm great. Thanks, Joe.
So if you could let the audience know about you and your legal practice in the employee benefits area.
Because I started my employment and benefits legal career over 30 years ago, my practice has developed during the same time that 401k plans have essentially replaced traditional pension plans and become the dominant retirement vehicle in this country. I started at a time when the phrase ERISA litigation didn't mean much, and now it's all that practitioners in the field talk about. From my perch, I have a very strong perspective on how 401k litigation has evolved and where it's likely to go.
So I've been hearing a lot about 401k plans in the news recently. Why is so much being written now about the problems with 401k plans?
I've seen those headlines as well. Here's a few examples. The dramatic rise in excessive 401k fee litigation and who's fighting it. Is your 401k plan at risk of a lawsuit? Maybe you should sue your 401k sponsor. Well, let's start by talking about the prevalence of 401k plans today. Did you know that employers sponsor over 600,000 401k plans for their employees? And those plans hold well over $7 trillion in assets. While a 401k plan is a completely voluntary undertaking, it does take what it seems like a village to run one. Trustees, administrators, record keepers, investment advisors, custodians, and of course, lawyers. Under federal benefits law, known as ERISA, those who run a plan have a fiduciary duty to participants and beneficiaries. One of those duties is that the fees that participants pay have to be reasonable, and the fiduciary has to know what those fees are and how they compare in the marketplace.
Have there been any lawsuits over these fees?
Exactly. What started as a few lawsuits brought by specialists a decade or two ago against only the largest of the largest 401k plans has now turned into a flood of more commonplace suits by more and more plaintiff attorney firms. Did you know that since 2020, nearly 300 lawsuits over plan fees have been filed? And in 2022 alone, settlements of those lawsuits exceeded $68 million. The U.S. Chamber of Commerce now regularly enters these lawsuits at their earliest stages in an attempt, so far not fully successful, to stem the tide. Let me share with you some of the things that the U.S. Chamber of Commerce says about these lawsuits. Quote, "This case is one of many in a recent surge of putative class actions challenging the management of employer-sponsored retirement plans. This explosion in litigation is not a warning that retiree savings are in jeopardy. Many of these suits cherry-pick particular data points, disregard universally understood principles of plan management, and ignore documents that are judicially noticeable. The complaints typically follow a familiar playbook. Using the benefit of hindsight, these lawsuits challenge the decisions plan fiduciaries made about the investment options or the arrangements fiduciaries negotiated with the plan's service provider. These lawsuits then lean heavily on ERISA's perceived complexity to open the door to discovery, even when their conclusory allegations are belied by publicly available data. No plan, regardless of size or type, is immune from this type of challenge. Plan sponsors and fiduciaries today truly are, as the Supreme Court has observed, between a rock and a hard place. And that's all according to the U.S. Chamber of Commerce.
So you said in 2022, settlements exceeded $68 million. What makes these types of lawsuits so costly?
A lot has to do with the fact that these types of suits are easily and almost always brought as class actions. A lot has to do with the fact that trial courts are reluctant to dismiss these suits at the outset, and the resulting discovery is very expensive. And frankly, a lot has to do with attorney's fees. Under ERISA, parties showing only some success is entitled to be reimbursed for their attorney's fees.
So what can a company do to protect themselves?
Surprisingly, quite a bit. ERISA is all about process, and an educated fiduciary that follows and documents a careful process is way ahead of the game. It's precisely these safeguards that I will be discussing at an upcoming seminar entitled Managing Your Company's 401k Plan and Avoiding Excessive Fee Lawsuits that we're sponsoring on Tuesday, September 26th at 5:30 p.m. I have the pleasure of presenting along with a preeminent 401k investment advisor, Harris Neidick, and the author of the book, Common Financial Sense, Simple Strategies for Successful 401k and 403b Retirement Plan Investing. Information about the program and how to enroll can be found at the link in the description to this podcast.
So if any of our listeners have any other questions, how can they get in contact with you, Jay?
Also linked to this podcast is my contact information and my bio on the Brock Eichler website.
Thank you so much, Jay. It's great talking to you.
My pleasure.
Thank you for listening, and for more information, please visit brockeichler.com. Brock Eichler LLC is a full-service law firm based in Roseland, New Jersey. With over 80 attorneys, the firm is focused on the following practice areas: healthcare law, real estate, litigation, trust and estates, business transactions and financial services, personal injury, criminal defense and government investigations, labor and employment, environmental and land use, family law services, patent, intellectual property and information technology, real estate tax appeals, tax, and cannabis law.